Welcome and thank you for joining today's webinar. I am Wynette Harewood. A few housekeeping announcements. The Roundtable Business Series is sponsored by the UWI Arthur Lock Jack Global School of Business. We are streaming live on Facebook and YouTube. Today's session is also being recorded. Please keep your microphone muted during the webinar. We invite your questions, so place them in the chat or Q&A tabs at the bottom of your screen. We have allocated some time for Q&As with members of the panel. So let's meet our panelists. Janet Peters is the holder of a Master in Public Sector Management from the University of the West Indies, Mona, Jamaica, a Legal Education Certificate from the Hugh Wooding Law School in St. Augustine, Trinidad, and a LLM in Commercial and Corporate Law from the UWI Cave Hill, Barbados. She has significant work experience and expertise in the areas of finance, administration, and corporate law, and has served in the role of corporate secretary or legal officer at many public institutions, for example, Kashta, the Accreditation Council of Trinidad and Tobago, and the Public Services Credit Union Cooperative Society. She is currently employed as the Corporate Secretary and Head of Legal at 𝗖𝗿𝑇𝑡. Janet has served on several national committees, including the committee that drafted the legislation for the establishment of the Accreditation Council of Trinidad and Tobago. Ms. Peters is a lecturer on the Master in Human Resource Management program at the Arthur Lock Jack Global School of Business. Mr. Clyde Weatherhead is an attorney at law with more than 20 years practice in the areas of employment law and industrial relations. Clyde is also the holder of a BSc in agriculture and worked at the Agricultural Development Bank Limited. It was there he joined the Public Services Association, PSA. He was elected to the position of Secretary-Treasurer and then President of the PSA for the period 1990 to 1997. After serving in the PSA's executive, Clyde was engaged by the ILO to undertake research work that informed the development of the workplace policy on AIDS for Trinidad and Tobago. His research also contributed to various initiatives on the Program for the Promotion of Management and Labor Cooperation, PROMALCO, in Trinidad and Tobago and other countries across the English-speaking Caribbean. At present, he is an adjunct lecturer in law, employment relations, and negotiations at the Cipriani Labour College, Kashta, and the Roy Tech Institute. And our last panelist, Kashta Ome, is a human resource management and industrial relations professional with more than 20 years working experience. He has worked at the senior executive level in both private and public sector corporations, and there he has dealt with numerous issues relating to organizational restructuring, talent development, negotiations of collective agreements, management of disputes and grievances, advocacy and representation at the Industrial Court and at the Ministry of Labor. He holds a BSc in Management Studies and has an IMBA with a specialization in human resource management from the UWI Arthur Lockjack Global School of Business. He currently serves as a member of the Employee and Labor Relations Committee of the Trinidad and Tobago Chamber of Industry and Commerce, and is also one of the employer representatives to its Industrial Relations Advisory Committee. Janet, Clyde, and Kashta, welcome, and thank you for being part of today's webinar.
Morning, Wynette.
Wynette, thank you very much.
Good morning.
It's a pleasure to have all of you and to see you again. I understand we have persons logged in from across the English-speaking Caribbean, even Guyana and the USA, representing a wide cross-section of industry sectors. So we truly have an international audience this morning. Today's topic, modernizing approaches to labor relations in the Caribbean, is timely. But before we jump in, I just want to share three what I call historical tidbits. Last month, May 1st, was International Labor Day. And that was celebrated in also some CARICOM countries, because that's the day, you know, that's been set aside by the ILO to really pay tribute to workers and labor. This week, on Tuesday, the 15th of June, was the 41st anniversary of the assassination of Dr. Walter Rodney in Guyana. At the time of his untimely passing, Dr. Rodney was the co-leader of the Working People's Alliance Party. And on Saturday, June 19th, 2 days coming, we here in Trinidad will be celebrating Labor Day. That's our Labor Day. And the labor movement has indicated, I read a newspaper article, of plans for a virtual celebration due to the COVID-19 and the state of emergency restrictions. So there is still going to be celebrations. So with those tidbits said relating to labor, let's get into the meat of our discussions today. When I think about approaches to labor relations, I think of the factors or the items that influence the rules of engagement between the three main actors, that is government, workers and workers' representatives, and employers and or their representatives. And these factors that shape their interactions and discourse have traditionally been the tripartite approach, social dialogue, collective bargaining as it relates to wages and terms and conditions of work for employees, labor laws, grievance handling procedures, disciplinary procedures at the workplace, and of course, the ones that I say that are not so, a little bit unsavory, you know, the strikes, lockouts, threats, intimidations, and so on. Is that a correct understanding? I know the list is not exhaustive, but is that a correct understanding?
I want to agree with you, Wynette, to some extent. Tripartite, I am not too sure how much I agree, but I tend to agree with the adversarial nature of the relationship at this point in time. The traditional approach has been adversarial and continues. And even as I looked at some of the questions that were raised for today's chat, you would see people asking the question, why is management so adversarial? How do we operate in this changing environment? Changing environment in several ways. One, the whole concept of globalization, and the need for competitiveness as we move away from protected markets. And people asking, how much power do managers have over us as workers in terms of literally mandating that we access this COVID-19 vaccine? So yes, I think that the relationship has been adversarial. There is need for a shift in terms of social dialogue among the partners and the key partners, including but not limited to human resource managers. So I do agree to some extent. Tripartite, I am not sure if all the countries can really say there's a tripartite approach, given the adversarial context and climate. And I guess it stems from our historical origins in terms of how we operate. But as I looked at some of the questions and issues, one saw in them this divide, this division between these two factors that are supposed, or factions that are supposed to now come together as the social partnership.
Thank you, Janet, for that response. And I would now open the floor to any other quick comments from either Kashta or Clyde in terms of how you see, from your perspective, where we are in terms of these labor relations approaches as it is today. Clyde or Kashta?
Okay, I'll go. So thanks again, Wynette, and good afternoon to all our listeners and viewers. Good afternoon to the other members of the panel. I just want to say thanks to the LockJack for asking me to be part of this discussion, and it's a pleasure to be among such a esteemed company as Mr. Weatherhead and Ms. Peters and yourself. And it's very instrumental that we should be having this discourse at this particular time, right? My request is that, after today's session, is that we can move this conversation into some more practical solutions and some success stories, right? And I want to agree with Ms. Peters, because the challenge that exists with labor relations in the Caribbean is not a new problem, right? There is that historical context in terms of how our societies were built and how our societies were developed. And in fact, issues in labor relations are a commonality, a historic commonality in all our industrialized environments in the Caribbean. And as such, you mentioned the work that was done by the ILO with respect to the 𝗏𝗏𝗀 initiative. And this initiative started way back in the late 90s, if I'm not mistaken, to the early 2000s. Perhaps Mr. Weatherhead would provide some more clarity on my time frames. But this particular program was started because the persons at the ILO, the individuals at the ILO, recognized that Caribbean economies, by extension, in order to be competitive, and by extension, businesses, that they needed to be competitive in order to be able to survive in this current environment. Competitiveness is a complex phenomenon, and it's based upon several factors, one of which is productivity, which Ms. Peters would have also alluded to. And it's not only a key component for success, it's a key component for survivability. But productivity has traditionally been hampered within our environment by adversarial labor relations environment. It's often us versus them. And if I'm not mistaken, the 𝗏𝗏𝗀𝗀 document that was produced in 2004 actually described it as a zero-sum game. So the current framework is characterized by situations where for one side to win, another side has to lose. This dynamic needs to change in order for our businesses and for our economies to continue to thrive. In my humble view as a practitioner and somebody on the ground dealing with this on a daily basis, my approach is to try to build that environment for win-win solutions right in your workplace, in your departments at the lower level. Work within the framework. The framework, in most instances, has probably not been keeping pace with business, and as such, it probably doesn't lend a lot of assistance. But it doesn't mean that you cannot start having discussions within your work environments, starting to have consultations, and starting to have issues discussed openly without egos, and to have dispassionate conversations with your employees around how it is that we go next and what are the things that we deal with next.
She mentioned this issue of adversarial relations and so on. It sounded pretty much deja vu, because that was the kind of discussion that went on in that period of structural adjustment. You know, remember when the IMF was dictating to everybody how to redesign their economies when we were facing a serious crisis in the world back in the 70s into the 80s and certainly a little bit into the 90s. The notion of collective bargaining that Janet mentioned, and we have to look at it in this sense. She mentioned it in the context of wages and terms and conditions and so on. My view is that if we look at the definition in the Industrial Relations Act in Trinidad and Tobago, that collective bargaining has to do with all aspects of the employer-employee relationship. And it is not restricted to the question of terms and conditions and money and so on. There's been a long-standing argument that trade unions are living in some historic Jurassic age and are only concerned with wages and salaries and keeping jobs. If that were true, trade unions would have died a long time ago. The question behind all of this is, how do we get, because one of the things, as you mentioned there, I did teach, I'm no longer a lecturer at those institutions, but I did teach negotiation at Roy Tech. I was asked to teach it there. And my own training in negotiation is that I'm self-taught as a negotiator. When I was president of the PSA, I literally bought a library on the issue of negotiation and I examined the whole thing. I do not believe that we have what I would call principled negotiators largely in the sphere of industrial relations and much wider in the Caribbean. We have a lot of people for whom I win, you lose. And that's the zero-sum notion is there. But in the public service, which the PSA represents and which I had the opportunity to lead, there is something called the Joint Consultative Committee, the JCC, which was a product of Circular 1 of 1973. And in other areas, for example, where the PSA had bargaining units, such as in WASA and the ADB and etc., we set up something similar to the JCCs, which include both management and employee reps. And if you look at Circular 1 of 73, it says this is not to do only with grievances. This has to do with how work is arranged and so on and so on. So there was that was very strong, for example, at the CSO for many years. Sadly, I have been around the service in more recent years, and many of those consultative arrangements have disappeared. So one of the ways, as my brother just said, it needs to start in the workplace. And certainly I can say that in the public service, it was a mandate to have the JCCs. And in our collective bargaining in the PSA, certainly, and I know of some other unions, it's what they call non-crisis meetings. There has been an attempt to institutionalize that dialogue between management and employees and their representatives to deal with a broad kind of vista of the relationship in the workplace and not just grievance handling. And I think that is the kind of direction we need to keep going in or get back to.
Okay, so thank you, Clyde. So we're hearing that there are mechanisms, probably they're not being used properly for both the private sector and public sector companies based on what Clyde just said, using an example drawn from Trinidad and Tobago. So there are mechanisms. He talked about even the approaches to negotiations, and maybe we need to move away from the win-win distributive approach to handling negotiations and use more principle-based approaches to negotiations, and even broadening our understanding of what collective agreements cover and how they should be used. Kashta talked about having dialogue, and the human resource manager, as mentioned by Janet, also being a critical partner as one of the actors in this whole arena of labor management relations. So let's talk about what's not working, because when we talk about modernization, it means that whatever we have at present is inadequate, not fit for purpose, or needs to be tweaked, needs to be adjusted, and so on. So can we give, one example of one of the various approaches we have that's just not working?
Well, one of the issues, and I know it's been a sore point with the trade union movement for many years. In Trinidad and Tobago, we have compulsory recognition of trade unions under the IRA. But the recognition process is so difficult. There have been some unions that have applied for recognition in this country and had to wait 9-10 years for that process to be completed. And at this time, our trade union density, to use the term, the percentage of the workforce who is unionized, I think is closer to 10% than anything above that. And one of the big issues is that you have a lot of ununionized workers who have to be in the courts. And that's where people like myself, who are attorneys at law, get involved, because we can't take a matter to the industrial court. And there's no way, I know there's been a lot of discussion about individuals approaching the court, but the parties in the court are union and the employer. In terms of industrial relations matters, there are some particular matters that somebody could go as an individual, for example, with minimum wage issues and maternity protection and some of those issues. But generally, it is an employer and a union, so that if somebody is not unionized, they have no access to the court, literally.
All right.
I also think that what might not be working is who is a worker, and the definition of worker under the Industrial Relations Act, given the several new forms of employment that we see coming into existence at this point in time, in terms of the temporary workforce, outsourced workers who might be employed by one party, but really working for a third party, and the several different forms of arrangements that are coming into place, even migrant workers. And so at this point in time, the definition of worker might not really align with who is a worker. Even family businesses, you have several different connotations of persons who are working, but who may not be deemed as a worker under the IRA. So I do agree tremendously with Clyde in terms of the several persons who are at the periphery and who don't have access to a union or ease of access to a union, but you also have the definition of worker and how it needs to be interpreted and probably broadened to be able to provide the necessary guidance to those who might really most be in need of it.
Okay. Would that also include persons defined as contract workers? I mean, how does the law, the IRA deal, and I know it just is related to Trinidad, deal with contract workers?
And contract workers do get protection depending on how they are classified. You have contract of employment and contract for service. And sometimes employers are wise and they use the lacuna in the law to be able to classify a worker as a contractor under a contract for service rather than a contract of service. And so they too, depending on the interpretation the court applies, can find themselves sorely challenged.
Okay, so you see, sometimes sounds like there's some sort of bit of manipulation there sometimes.
Yes, there can be. There can be.
Yeah,
There can
of
be.
the law. Okay, so
Wynette,
yes.
I just want to comment on what would the discourse that would have been passed there. So I am fundamentally in agreement with what has been stated by Mr. Weatherhead and Mr. Peters. And yes, the legislative framework needs some work and it needs some adjustment, and I'll agree on that 100%. My philosophy as a practitioner on the ground has simply been this. The only way to win a matter at the level of the industrial court is not to go to the industrial court. That's a simple philosophy, right? The only way to win. My philosophy has been built on the fact that I believe that as a manager in an organization, as a leader in an organization, that I am always open to conversations with employees, employee representatives on any matter, and that we could resolve matters and we could have matters dealt with in a dispassionate environment that allows for resolution, right? The approach is simply that in the cut and thrust of business in terms of where we need to focus our energies and how we need to go about changing that environment, it starts with little steps. It starts with building trust with your employees, ensuring that everybody understands. It starts with building a consultative approach. And of course, you will still have situations and circumstances where opinions may differ on particular issues. And when it asks the question in terms of what is the main challenge, and from where I sit, one of the main challenges is that within businesses, within work environments, there's an overall lack of knowledge of what the framework allows for. What are the principles and practices of good industrial relations? And as such, one of my things that I do is to ensure that my team, my executive, my managers, my supervisors, all those on the ground who interface with workers, that they understand what are their rights, they understand what are the employees' rights, so that when situations and circumstances come up in their area, they're able to treat with it in a way to resolve the issues, right? So this is before we even reach to non-crisis. This is before something even reaches to a grievance or enters into a grievance process. So my whole thing is, as much as possible, to resolve situations, to increase persons' knowledge and understanding of what the framework allows and what it doesn't allow, to increase opportunities for employees to feel that they can go to their manager and have issues discussed and not have to face issues along victimization or that their rights are going to be infringed and that sort of stuff. So for me, and of course, remember, right, the non-unionized could still go as to a minority union, seek membership, and they can have a matter taken to the court. So the non-unionized have that option. But what we need are, in our organizations, where these things are taking place on a daily basis, if it is that we are talking about modernizing our approaches to labor relations, then all the principal parties in places in organization where labor relation tends to happen more must know what is the framework, what are the rules, what are the practices, what are the principles, so that we won't do things that would put us in a situation where we have to go to court.
Okay.
Could I add
yes,
something?
Sure. Great.
Because a couple of things have come up here. And let me congratulate Kashta if his approach is having his management people trained. One of the difficulties I've seen in recent years in the trade union movement is that if you go to the industrial court, you will see attorneys at law representing trade unions in the court. In the early days of the ISA and then the IRA, you would have had trade union officers actually conducting the cases, because in good industrial relations practice is what is at the heart of what the court decides. And in my own experience, when I first started to go to the court as a union officer, I had cases against several attorneys at law, and at that time, I have never lost a case in that court. So this is not a matter of law. This is a court of law and industrial relations. And one of the difficulties is when I was asked to teach industrial relations at Kashta, and forgive me for mentioning the institution, but it was my experience. Within 2 years, the industrial relations component of the HR program was moved to an elective course. And then you had a whole drop-off in the number of the students who wanted to do the course. And I couldn't understand, how could you be training people in HR and not have them be required to do industrial relations as part of that training? Because you're then going to have people going into the workplaces, precisely as Kashta said, not understanding what the framework is, what the responsibilities are on both sides, and it's a difficulty. On the other hand, the trade unions seem to have lost the institutionalized training of their officers from branch level to executive level to conduct industrial relations work. And that does not help either the union or the employee relationship in the workplace.
Okay, so I'm taking away, or I'm hearing that we have deficiencies in terms of capacity and capability in the side of workers' representatives, and also in terms of human resource managers, in just managing this whole relationship between labor relations as it applies in the world of work. And there's probably need to build capacity and so on.
Wynette, let me just add one thing to what it is that you're saying there, please. And it seems to me that there's a lot of responsibility in this particular regard being placed on HR managers. For where I sit, industrial relations and human resource management is a function and not a department. And as such, it has to be something that is echoed by every single manager, supervisor in an organization. So that is the goal, to make sure that all of these persons who are in leadership positions, all of these persons who are responsible and sometimes I don't even like the word workers, I prefer partners, right? To be seen, to have that knowledge so that they know what decisions are they going to make. And it shouldn't be just left up to the HR manager, as the case may be, but that everybody has that knowledge that allows them to understand that framework. I just thought I should add that.
Okay, right. So everybody is involved in this whole process of ensuring that relationships work well. Any thoughts on the role of the employer? Because we've had a lot of discussion here on the other two parties. Any thoughts in terms of how they have fared over the years in this arrangement, in terms of what they may be doing well or where there may be deficiencies on their part in terms of the employer or the employer's representatives?
When I think of the employer, I think of the organization as a whole to some extent. And it goes back to my thinking of the role of the HR manager as the subject matter expert in providing guidance to the employer and to the other managers. Because if we were to zero in a bit onto the COVID-19 situation that people have been asking about at this point in time, and you think about the employer, what you see is that managers generally tend to operate in a culture of distrust. So now workers have become invisible. Workers are no longer before their eyes, and maybe there might have been micromanagement when you look at the employer in their quest for productivity, that elusive productivity, which might not bear fruit in an environment where you have mistrust. So when you look at the employer in terms of what has been happening, it has been in the face of global changes. It has been in the face of sometimes unions demanding higher wages based on the cost of living and not on the competitiveness of the company. And it has been now a new normal where workers are now required to be away from the workplace, and you might have significant mistrust. And really, I speak to the HR manager as being crux, notwithstanding the importance of all managers having knowledge and being guided, but the HR manager being really at the forefront now to guide the employer and to guide the managers and to help them to understand how to navigate in this new normal and how to generate productivity and how to create trust, how to recognize the psychological challenges that workers are facing at this point in time and the other challenges, and assisting them in being able to settle into this new environment. So it is not that the employer has been doing no good, but it is the employer operating also in a certain environment of recognizing the need to stay afloat and wanting to stay afloat in the face of increasing wage demands and other demands. And I do hear Clyde's point, other demands, but the focus being on wages and cost of living and the management sometimes not having that level of trust that these invisible workers produce.
Okay. If we can move forward in terms of the current challenges facing us brought on by the pandemic, all right, because there's a lot of concern and discussion now about vaccinations, about the security of workplaces, whether a vaccine should be regarded as personal and protective equipment and so on. And Clyde, I saw where you wrote, I think it was in this Daily Express, an article talking about the need for social dialogue on workplace vaccination for employees. So could we talk about, what are the issues here regarding vaccination? What is not covered in the existing arrangements that we have? Why has vaccination and employees being vaccinated in order to return to work become such an issue?
Well, the fact is we are in a pandemic, and one of the ways for us to get out of it is the possibility of vaccination to a certain degree in the whole society. And certainly this applies to the workplace. For example, we've had the case where a worker was working offshore on a rig, and he became COVID positive, and he went home and had to be isolated with his family. And both he and his father died within hours of each other. The question is, how did he on a rig out in the sea get COVID? So the question has to be, and I've seen several discussions up to this morning on television, where it is being posed in the context of individual interests and social interests, meaning the society's interests. The reason I suggested the urgent requirement for social dialogue on the question of developing a policy on this question in this country was to avoid having individual employers taking it upon themselves to decide that there should be a mandatory requirement for vaccination in their workplaces, which will only lead to a number of disputes going to the court and elsewhere, which I think would be distracting from the social problem we have of getting out of this pandemic. So to avoid unnecessary fights, as I call it, let us sit down together and work this out. And in this situation, as you know, in this social partnership kind of arrangement, government gets two bites of the cherry because it is both the government and an employer. So the issue has been raised. I've seen the OSHA in the United States in May come up with one policy with respect to vaccination requirement in the workplace. And on the 21st of May, I think it was, they said, well, if the employer requires it as a mandatory thing, they must be prepared to deal with the situation where an employee may become ill as a result of the vaccination and treat that as a workplace injury. And within 3 days, by the 24th of May, OSHA in the United States reversed that whole position. So it is not a settled issue. I've seen in one discussion, somebody referred to the International Convention on Civil and Political Rights and said based on that convention, nobody can be forced to take a vaccination. Certainly in our country, there's no OSHA regulation. There's no law passed by the parliament requiring vaccination as mandatory. So in the absence of law, as far as the workplace is concerned, I think the same thing to do, and the government should initiate it as far as I'm concerned, is bring all the parties together. Let us work out how we are going to address this in the workplace.
Okay, thank you, Clyde. Kashta or Janet, your comments on their view on this?
I agree with Mr. Weatherhead on the need for continuing conversation, because it's an area that there are arguments on both sides for and against. And yes, the debate is going to come down to the issue of individual rights versus the rights of the society and that sort of stuff. And you put inside of there OSHA, which places a responsibility on an employer to provide a safe working environment. And as such, you also put inside of there the comments that would have been made by the Prime Minister that an unvaccinated person presents a risk, and talking about maybe that person needs to be moved into another area. So of course, there's need for that social dialogue. There's need for those conversations. You also have the situations where there are certain businesses or certain organizations that are deemed essential. And because of the nature of the work environment that these workers may have to work, or how it is that they work, they may be in close contact with one another on a regular basis. It may not be suitable for them to wear masks. They may be working in hot environments, and I'm speaking hypothetically here. And as a result of that, the risk of those workers, because of the importance of the jobs that they do, they need to be given as much protection as possible in the circumstance. So there are conversations that we need to get into. I mean, how do we look at the issues of our frontline workers? Should they all be mandatory because they're in a greater risk? Police officers and persons who work in those types of military services, they are going to be interfacing on a much more regular basis with the public, and as such, do we then make it mandatory for them and not for others? So there's a lot of questions and issues that need to be explored in this particular area. The one thing that I would say is that the first company that comes out and says, look, through a nice process, and not a mandatory unilateral process, but through the process of conversations and engagement of their staff, that comes out and says that we have achieved herd immunity in this organization. We have 70, 80, 90% of our staff fully vaccinated, would have a very unique competitive advantage. And that's also something that we need to think about.
So we're hearing that this current situation here of vaccinations and treating with it is something that we recognize that needs to be discussed, but the discussion is not taking place. Why is there this social dialogue? I don't know if it's a reluctance or to get the dialogue going, even though there's recognition that we need to talk about it for the reasons that you all have indicated. Any thoughts on that?
Again, Wynette, what I would say, right, is that a lot of these conversations have to happen on the ground. They have to happen in jobs, in businesses, in departments, right, in the organizations when we work. And it has to start there. And that's why you need a certain type of leader, certain type of employer to have a conversation with their staff and to try and encourage them as much as possible. As it is right now, our main challenge with respect to vaccines is accessibility. But should there be a situation where an employer, and we reached a situation where vaccines are easily available. And remember, vaccines are not new to us. I believe most of us, in order to enter the primary school system, must have had to have a vaccine. So there is some mandatoriness, so to speak, involved in our system already as it is. But we have to start to get into those convincing conversations on the ground level with Joe Brown, with Susan Brown, with James, with Stephen, and say, look, here's what's happening. The best chance for you to get out of this thing is to get vaccinated. You know, if we are able to achieve herd immunity in our company, we will have a competitive advantage that nobody else would have. And people will flock to us because they feel comfortable dealing with our staff, right? Have conversations and tell them the benefits of the vaccine. Have conversations and tell them which one what are some side effects that you may experience. The ability for life to get back to the so-called normalness that we seem to continue to want to achieve. All right, and have those conversations to convince people in a truly engaging way, rather than the use of the word mandatory or unilateral be the approach. And of course, still continue those national conversations on it. All right, we can't afford to wait for the government and the national tripartite people to come and tell us what we should do. We should be making our rules up for our companies and organizations within the framework.
May I add this, Kashta, that while you say, the employer and his employees in a particular business may focus and achieve herd immunity within the business, the fact is that employee has to go home and has to live in a community and these vaccines are not preventing transmission.
Good.
These vaccines, we are told, are only preventing the worst outcomes.
Yeah.
So that this issue, and when you speak of frontline workers, I noticed you didn't mention health workers, who are the most frontline. Because
I think I did. If I missed, I apologize.
you went to the police, I think.
Yeah.
But the point is, there are situations like this. That's why I think it is the government's responsibility, having total overall charge of dealing with the epidemic crisis, to pull the parties together and say, listen, there's a particular situation we need to talk about. What about the workplace and vaccination? We need to talk about that. They also have to consider, as government, do we need mandatory vaccinations in the society? And if we need that, then it is there to take legislation to the parliament and get it passed, or to have regulations produced by the OSH authority and so on. So it is something that I don't think is a conversation to come. It should have started about a month ago, or if not before.
I agree with you. The national conversations have to happen and they are needed. My thing is that I'm not waiting for it to happen. I'm not waiting and whilst, I appreciate the persons putting pressures on the government to have that type of thing. Unfortunately, there has not been a significant demonstration of our political will to treat with things like these on a national level. So for me, and from where I sit on a practical level, I know that, look, here's what's happening. This is going to be good for my company. This is going to be good for the community that my businesses support. This is probably going to be a strategic advantage for my company, or a competitive advantage. So I'm going to try to make it in my little space. I'm going to take the messages home, and I'm going to encourage my employees to take the messages home to their homes and to their communities. And that way I could have some type of spread within my little space that I could influence. I can't just sit back and just say, well, we'll wait for the government to make it mandatory and, that sort of stuff. I had to do what I have to do as an individual. You understand? So my thing is that when we're talking in the context of modernizing approaches to labor relations, this is an excellent opportunity for us as persons in business on the ground in terms of labor relations to start opening conversations, conversations without egos and dispassionate, with our employees, with our employee representatives, and say, look, you know what? The government will come eventually and do this thing. Let's have a discussion. What do you all think about it? This is something I think we should try to encourage. Not mandatory, but encourage, so that we could reach and achieve herd immunity. Herd immunity is not 100%. Herd immunity is somewhere between 70, 80%. And that, I think, is achievable in our organizations without government.
Okay, so I'm hearing two different approaches in terms of this modernization, in terms of labor relations to deal with this issue. At one level, there's a need at the macro level for the government, who is both as the government and also as an employer, to put in the legal framework and talk at the macro level about this issue. But I'm also hearing Kashta saying at the local level, at the micro level, at the organizational level, human resource managers and employees, in fact, all the leadership in organizations should really be starting to have these conversations based on trust, as Janet talked about what is affecting us, how we are all in this together, and what we need to do collectively to ensure that we all benefit, so we all get a win-win. So we're really adjusting the situation on two levels, yes?
Yeah, so Wynette, in terms of, it is like collective bargaining. This should not be a win-lose situation.
Exactly.
So I'm saying both approaches need to go on.
Yeah.
Yes,
both
almost simultaneously.
Yes.
Yeah. And as you say, collective bargaining, it also means we will have to change or adjust our approach to collective bargaining and not just see it limited to wages and terms and conditions of employment and the traditional things that we talk of under collective bargaining. That collective bargaining can have a broader conversation. It doesn't have to be at once a year, when it's time to renegotiate and so on.
And even innovating in the workplace in terms of how we operate in the workplace, even when we actually might resume a semblance of some of the old normalcy, innovating in how workplaces are set up and how people are allowed to work, because you will find people who may raise the claim that they are being discriminated against if they are forced, especially at the micro level, to be vaccinated. And then you will see the court flooded with these matters being treated on sometimes a case-by-case basis. So even in terms of being innovative, as we have this social dialogue, which is really, really critical so that it doesn't happen on a piecemeal basis where one organization takes one approach that might tend to be very high-handed as opposed to another organization. So being innovative, because at this point in time, I do not think that one can say, although it is happening, the reality is that vaccination is mandatory and that you can be dismissed for not being vaccinated.
We're coming up to, we're going to be opening up in a while, next couple of minutes, to Q&As from the panel members. But I just wanted to raise one other issue, and I'm going to tell you there are probably some questions coming up about vaccines again, because we've had quite a number of questions in that area. But work from home, one of the effects of the pandemic is that it has just changed the whole approach to work, and persons are now working from home. And if we're thinking post-pandemic, with people returning to the world, returning to the work, or continuing into the work in this new arrangement, any thoughts on how we could currently deal with that as we get beyond the pandemic in this new environment of how people are working from home? Should we go back to the old arrangements, or do we have to now take this on board as a new way of engaging people at work in terms of working virtually or electronically or working from home?
I think that this is something that should be taken on board. I think that many organizations have recognized the significant benefits that can be derived from working at home. I look at the traffic situation as one, and people having to get to work for a certain time. And from working at home, people being able sometimes to be more productive, notwithstanding the situation that is faced in many quarters where, like I say, managers are not fully au courant with working from home and the invisibility of their workforce and the absence of trust, of course, in terms of not being able to micromanage. But I do think that a hybrid system can be developed because there are significant benefits, especially with technology and the significant technology changes that we have actually been able to benefit from. But I do think it is something that can be considered, can be discussed, and can be successfully implemented within this new normal that we are moving towards as we continue to also still grapple with the COVID-19 situation. I do think that people have been productive. There have been the downsides, of course, in terms of psychological trauma, some people not being prepared in terms of being fully equipped But I do think that working from home is something that can certainly be done to the benefit of several persons and to the environment, of course.
Okay, all right. Another issue coming up has to do with the whole issue of mental health in the workplace as a, yeah?
Can I just comment on that question that you
Sure.
asked? All right. So the first thing that I think we need to recognize is that this whole notion of working from home and remote work is not really new, right? It was something that was trusted upon us and forced upon us in the circumstances of the pandemic and us trying to figure out how to deal with it. But remote work and that sort of stuff is something that has been going on all over the world, all over the Caribbean for long periods of time before this whole COVID thing come up. The challenge is that we were thrust and put into a system where we didn't know how to manage and we didn't know how to lead. And as such, we had to quickly abandon the traditional presenteeism type philosophy where you had to actually work is something that is a place that you had to go to and not something that you do. So there was a lot of trauma in terms of how do we manage. We had to get laptops in short demand in the world and that sort of stuff. But we have been in this system now roughly about 18 months, and we are getting better at it. And trust me, I agree 100% with Janet. I enjoy driving on the highway now. I enjoy driving on the roads now, right? I don't mind driving in the car. Before I used to take my bike and go out to get whatever I needed to get out the road. I drive now. It is so lovely. And the fact of the matter is that we will continue to see more and more benefits of this approach. The challenges, of course, is balancing working from home and also for parents, especially having to manage their kids in school at home. And that is a great challenge. But once the society starts to return to some level of normalcy, and as you would see in many, many documents and in many, many articles coming out of the US, a lot of workers are actually saying, you know what, if it is that you're going to ask me to come back out to work, I'll quit my job. I prefer some type of hybrid situation because persons have, and I believe it may be linked as well to the point that you're going to make, that persons have now started to enjoy certain things. People are getting back into gardening, people are doing cooking, learning new things, all because now they are more at home and enjoying some of the benefits of being at home. I think it's here to stay. I think there are so many benefits that come from it. That is here to stay. Of course, it's not for each particular job. There are some jobs that actually have to go to a place to be performed. But for those of us that could work from home, I think that is something that we are going to have to understand and appreciate that this is going to be a factor of our life going forward.
Right, so if work from home, thank you, Kashta, if work from home has become the new normal, then it means in terms of areas like managing employees, performance management, accounting for persons' times and so on. All of those systems that we currently use now will have to change, and will have to be adjustments in policies and perceptions about how do you determine attendance, how do you account for punctuality and productivity and so on, what constitutes a day and people being available. So those are a lot of changes that employees and the workers' representatives would have to understand, kind of revisit and come to some agreement on how do we treat with these areas going forward. Because as you said, the traditional approach is that you account for the persons by seeing them, and they sign in and they clock in or whatever. And that's how you know that they're there and they're working. But that certainly is going to change with this work from home arrangements.
But Wynette, as Kashta said just now, this has been going on, in my recollection, since the 80s. But, but it has not
hasn't
been
probably been embraced and used.
And it hasn't been introduced on a national level and so on in many places. So the question is that it may have been like in Trinidad and Tobago, one or two people may have been doing it. For example, myself as a sole practitioner in law, I have to work home and in an office. In fact, when I first started practice, I put a globe on my call card, and somebody asked me where my office is. I said, that is it. So he said, "What do you mean?" I said, "Well, with the modern means of communication, I have a client in Jamaica. I never been to Jamaica to talk to him. He never been here, but we talk and I take instructions and so on. For example, one of the benefits of COVID is that, for example, in legal practice, in 2000, when I was in law school, there was big discussion about the new civil rules and that we would be able to file documents electronically and so on. 10 years ago, we were told the same thing, that a new registrar was appointed and he would be in charge of it. But here comes 2020, and suddenly what we couldn't do for 20 years, we are doing it every day now. So that the fact is too that a lot of government services are now being done on the basis of appointments. I renewed my driver's permit earlier this year. I had to go to Sangre Grande. I was there and back out in 20 minutes. And I met 2 people there, and when I was leaving, 2 other people arrived. So there's no crowd, there's no issue like that, and work can be organized in a better way. In fact, I heard last week that the CPO said that they are noticing higher levels of productivity in the public service.
Oh, really?
Since 1980s, they have been battling down the unions when we recommended that there should be staggered hours and so on. And their argument was, before 8 o'clock, we can't supervise people, and after 4. So I'm glad to hear them say that productivity could take place without a supervisor sitting next to you.
Okay, so I'm glad to hear that, because it certainly means working from home would now be an option, it seems, going forward for employees. Not something to be done on an ad hoc basis, but it will definitely be an option when we're talking about coming to work at a company X. One of the options is that you can work, from home, or have staggered hours, or have a blended arrangement and some sort of things.
And
okay,
remember,
so
too, Wynette, if you just permit me, when I look at the topic again and we talk about modernizing approaching to labor relations, this is definitely one area where we have that opportunity to modernize and to change our interactions and to change the whole nature of what work is and the concept of what work is. I mean, you have all of these companies now that have come up that are doing food delivery that allow you to get all different types of services. This is something that we in business and we as a nation should be looking to take advantage of, and it would require those conversations to change this whole concept of what work is. And when we talk about labor relations,
how we need to interact. Okay, so we're going to take some questions now from the audience. And I have one question here, and it has to do with the area of contract work. And it says, this is in relation to Trinidad. Are persons who are on short-term contracts, that is 3 to 6 months, are they entitled to sick leave? Anybody wants to take that?
Given our industrial landscape, in terms of what a worker is defined as, our worker is defined as that individual who does things for remuneration, etc., etc. I won't go into the long definition at this point in time. So when you say contract work, I understand that to mean that this person is a worker and not an independent contractor, but the person has a 3-month contract or a short-term contract, as it is. In most cases, traditionally, persons who are working in these conditions, their terms and conditions of employment would be defined as per their contract of engagement, all right? In that contract of engagement, there may be provisions for types of leave, and it will indicate how the person is supposed to be working and that sort of stuff. I cannot recall, and I don't recall any specific legislation other than the Minimum Wages Act, which actually pronounces on sick leave for workers and for a particular category of workers who earn a particular wage or within a particular wage range as defined in the minimum wages orders. So in many instances, especially in these short-term arrangements, which are supposed to be in and out, there may be circumstances where certain leave provisions are included for these short-term arrangements, and there would be provisions where it is that they are not. But other than if the person is a minimum wage worker, there are specific provisions in law for the provision of sick leave for workers who are receiving that minimum wage.
Wynette, may I just give an experience here? Because I encountered this early 2020 when I was asked by some public officers to speak with them. And there's this phenomenon in the public service, which I think is totally illegal, in which they are talking about short-term contracts, meaning 3-month or 6-month contracts, in which people are told you have no vacation leave, you have no sick leave. If you're absent from work, your pay is going to be deducted, and so on and so on. And I've seen it used in more than one ministry. Recently, I reviewed a case where people were moved from being 3-year contract to 1-year contract down to 3-month contracts, and then eventually asked to apply for jobs they were doing for nearly 15 years. So this question of contract work has been a sore point since the 70s coming up the road. And when you bring it down to 3-month contracts and people are not entitled to sick leave, I think that is downright illegal. But I've seen in some judgments of the industrial court that they actually recognize this 3-month thing and say you have no right to leave. I mean, this is ludicrous as far as I'm concerned. That cannot make sense. No worker can be in a job and not be entitled to sick leave. If something comes up, he doesn't make himself sick.
I want to agree with both Kashta and Clyde in that there is the minimum wages legislation, which allows for 6 months where people can acquire sick leave. But I do find there's a challenge in that the ethics of some employers have to be questioned, because they will hire you for 3 months in the first instance and then break your service for 1 week and then rehire you for another 3-month period. And so you could find somebody working for a year, a 2-year period, and not being entitled to any sick leave simply on the basis of the lacuna that the law, that is in the law. And to that extent, it links to the ethics of the employer and the fact that the workers' rights are compromised to a significant extent, because, as we say, sickness is not called upon yourself, and we're not speaking of malingering here. So I do find that it can prove challenging depending on how the contract is crafted. And like I say, most times the contract is crafted in favor of the employer, and it goes back to that mistrust and antagonism. And if we want productivity and really want real productivity, how this social arrangement and social partnership is so critical in terms of moving forward and modernizing the system and also really getting the much needed productivity.
Yeah, I agree. Mm-hmm. Sorry, go ahead, Wynette.
You go on, I'm sorry. Mm-hmm.
Yeah, I say I agree totally. And that's why when I talk about us having to move away from the traditional approaches, the fact of the matter is what Janet is referring to, is that the structure and the format and the framework sometimes doesn't help business, and it allows for these loopholes to break somebody's service and to bring them back and all of that sort of stuff. And yes, those things need to be tightened. I agree 100%. I certainly would not be one that would want to encourage anything like that. But at the same time, it really comes down to, on the ground level, on the base level, how much are we willing to do the right thing? And once we know what the law provides, some persons are going to be, well, look, I cannot accept this contract because I'm not seeing you putting in any benefits. Let's have a conversation about benefits. For this 3 or 6 months, can I have at least 1 day sick leave a month, paid sick leave or whatever it is? And then you enter into a negotiation, right? Our system, however, is a little bit different from the other systems that we tend to look at. And when I say our system, which is Trinidad and Tobago, and we tend to look at, of course, what takes place in the UK, in the US, et cetera, et cetera.
Okay. So seems we need to revisit this whole notion of contract works and how contracts are crafted, whether they, especially those short-term contracts, in terms of how we offer them and what is made agreed between the parties. Another question here coming up as it relates to the area of drug testing. This participant says, Are there laws with respect to drug testing? I recently was forced, that's the word written there, to do a drug test whilst on my period. I told them that I had no issue doing it orally or otherwise. They still made me do the test and it was negative, but they humiliated me. My manager was a man. I'm not seeing the rest of the question. Okay, my manager was a man who asked me personal questions about my periods. Any response to that? Sounds like some ethical issues there, but. So the question is about drug testing. I think that broader question of drug testing and employees being forced to take a drug test.
As far as I'm aware, the issue of drug tests in relation to the workplace is a matter of collective bargaining. And there, again, there is no mandatory thing like vaccines, for example, at the moment. So, and if a manager is asking an employee about the health situation and personal things, as she points out there and so on, something is definitely wrong with that. In any case, no manager should be doing a drug test unless they are a medical person. So those arrangements should be agreed between the employer and the employee. And the question also arises of how do you protect the data coming out of those tests? And we do have data protection law in Trinidad and Tobago that is being developed at this stage. So there's not just the test itself, but the question of how do you protect the information thereafter.
So I'm also hearing that employees need to be better informed about their rights and what are as was mentioned earlier, what are the correct protocols and ways to do things and what's acceptable and not acceptable, what is in a collective agreement and what can be the employer can ask of them and what's not.
What is in the contract permissible. Of employment, what is in the company's policies, what are you aware of when you come into the organization based on the nature of the job and what is involved. But it shouldn't be that it is something that is the manager can spring on you at short notice. No pose personal questions of an embarrassing nature to you. So it might be that you are a driver and you're not allowed to be inebriated on the job, but your terms and conditions, whether it is a collective agreement or your individual contract of employment and company policy, should guide you on significant policies in the organization and how they operate. But that particular case seems to be one that is out of the ordinary and really should not have happened.
Yeah, okay. Yeah. I find it a bit strange as well. But what I would like to add to this conversation is that in some companies, based upon the nature of their operations, and because safety is such a big issue in terms of their operations, they have mandatory drug testing at certain times or random drug testing to make sure that employees are within the bounds. And of course, these rules or these policies would be known to you at the time of employment, and you know it's a regular practice within the organization. You also have situations and circumstances where you believe that a worker may be under the influence of an intoxicant. And in those circumstances, OSHA gives you a particular responsibility as an employer to determine or to have determined if this employee is fit for work in the circumstances. So if it is that you believe that a worker is under the influence of an intoxicant, by observation, you may get a particular smell from that particular worker, you can ask that worker to withdraw themselves from work and ask them to go to a medical practitioner who will undertake a test to determine your fitness for work at the time, right? That test may be a drug test. It may be a breathalyzer or whatever. The test is to determine if it is that the individual is under the influence of any intoxicant.
All right. Here's another question as it relates to employees, knowing of their rights and so on. What can an employee do if the company changes their terms of employment without consulting them? That is, without consulting the employee.
That is where this discussion on the mandatory vaccination came up, and I see the president of the industrial court kept the discussion within the confines of the need for agreed changes to terms and conditions on a contract level. Any unilateral change in your terms and conditions, particularly of a fundamental term, allows the employee to say, listen, if you have changed my terms in a negative direction and you are doing that unilaterally, I do not accept that, but I can accept it in a certain way by resigning and claiming constructive dismissal. So anytime you act in that way as an employer, you run in the risk that you are going to be facing the industrial court or the civil court, because constructive dismissal can be raised as wrongful dismissal in a civil court as well. And both of them can happen. You can go to both courts on these matters. So it is, again, a principle of collective bargaining and good industrial relations. Even if you have an individual contract should be negotiated. It is not a matter that I come for a job and you tell me, look, this is the contract signed. It doesn't work like that.
I'm sure you recognize, Clyde, that what you're saying does not occur in our workplaces, does not occur in terms of negotiating contracts between workers and their employers, even persons who work, in the gig economy and independent workers and so on. That's not the practice.
Even in the civil service.
It's not the practice. So maybe those are the things that we need to change. It doesn't happen.
I have had people come to me who are contract employees in the public service, and they are to receive their gratuity, which means they've come to the end of a 2 or 3 year contract, and they don't have a signed contract yet because it's not negotiated yet.
Okay.
But I would want to say that, in the organizations that I have been a part of, I have actually been in situations and circumstances where you present a contract to a particular person after discussing it, and they say, look, I have a change. Could I have X instead of Y, or could I have Z, and that sort of stuff? And then discussions take place there as to if this can be done or not in these circumstances. So I think that there is that opportunity, and there have been opportunities for individuals, and individuals need to recognize that there is a choice. So when something is presented to you, if it's suitable, then you accept. If it's not, then you enter into a conversation around, well, look, how do I make this more suitable to me in these circumstances?
Requiring there for employees to be very engaged and confident to enter into those kinds of discussions with employers. And probably again, not all employees have that level of confidence, to engage in that discussion.
And that's why we're talking now about how do we modernize our approach to create that environment. And that's why I say it starts at the ground level by creating that environment where a person could say, look, XYZ is the case. Look, I had a situation just quite recently with a worker who was being promoted into a position. And when we discussed what it was and that sort of stuff, they asked for certain things, and they asked if this could be done and that could be done. And we entered into a short conversation around where we could land at a compromise position in the circumstances, because the new position would have meant that there would have been some change in her terms and conditions as originally set out when she entered. And it's through that process of communication that we were able to reach the common ground and compromise in some areas, right? It can't be that it is you're just pushing something down somebody's throat and asking them to feed. The old saying says that you could lead a horse to water, but you can't force it to drink. Why are we forcing people to do things they're not comfortable with?
Well, people may tell you the labor market and they need a job, so they take what is offered. Another question here. How do we deal with onboarding new staff during a pandemic when the majority of staff are working from home? I guess this falls with your lap, Kashta.
Well, the easiest thing to do would be to have a situation where it is that you conduct your normal onboarding exercises on a virtual platform such as this, right? You can once you have a onboarding program where it is that the individual will go and visit and speak to different leaders in the organization and have an understanding of what takes place there. It is very much possible for that to happen on a virtual platform where it is that they can meet and interface with some of the other leaders in the organization. And when the opportunity does present itself, if they need to physically visit a particular part of the plant, they do so. And onboarding is a continuous exercise. In some cases, it goes on for 3 months or for 6 months, where it is that there are many different touch points for the individual. So I think it's very possible, and I know of a situation, one at least, where an individual was hired and has never even been in the country, and his whole onboarding took place with the company in Trinidad and wherever the individual was in the other parts of the world. So it is very much possible. You just need to be creative and innovative in this space.
And I think the technology now allows us to do a lot of human resource management activities differently, because you can move to recruiting, using e-services and online platforms and testing online. The whole notion of having, the interview face-to-face, the pandemic has thrown that out the window. I know companies are doing, online virtual interviews and testing and so on, recruiting and onboarding. So it's really about using the available technology in a different way to allow us to do some of the things that we have done in.
I had a colleague who told me he just completed his mid-year performance review with his boss in one of those Scandinavian countries, and everything was done online. So it is possible. Some cases is expensive, but it is very possible.
It's a rethink. Okay, lots of questions on the pandemic, so I hope you forgive me asking another one. If an employee is found to be COVID positive at work, should that be treated as injury leave? These are all new things.
That question.
I don't know, Janet or anybody.
I think it depends. If you contract COVID outside the office space and you come into the office, then it won't be injury leave, because once you use the connotation of injury leave, it could mean that the organization could have responsibility and it could have legal implications beyond the sick leave. But if you contract COVID, the reality is that you are ill and that you should be entitled to sick leave once you submit the requisite medical certificate. As to be treated as injury leave, it is quite a different story. If, however, you contract COVID while on the job, then again, there might be different connotations to that, because you may have, the organization may have some responsibility towards you. So the term injury leave, it depends on how it is being interpreted by the person who is asking the question. But if you contract COVID, no matter where you contract it, you are entitled to sick leave, because you are unable to attend work. You are unable to attend work. Even if you are working from home, you may be unable to attend work. Injury leave connotes something quite different to me.
Okay. Any other Kashta or
the thing, and I see this is another case or another type of situation where it forces you as somebody in business or in an organization and such to be a little bit proactive. And situations like this will come up. And to me, the simplest answer is that I don't think injury leave would apply in this situation, but there has to be some type of leave that you will have to put the individual under in order to classify their time away from work. Injury leave has considerations for workmen's compensation and all of those things coming down the line. The thing for me is that in a situation where somebody contracts it on the job and through the process of contact tracing that is determined, then the company should be proactive to say, well, okay, this is how we're going to treat with it. If you recall, at the beginning of the pandemic, the government introduced the notion of pandemic leave for within the public sector. And that immediately triggered conversations within the private sector as to, well, look, how are we going to deal with this? What are we going to do? And you started to hear stories about people being asked to use their sick leave, people being asked to use their vacation and all of that sort of stuff. And from my experiences in terms of dealing with it, we were able to, and when I say we, the team of persons who I was working with at the time, through the process of engagement with the respective representative labor unions, came up with a system in order for us to be able to treat with it, right? And this system was accepted on both sides, and it was universally applied, and it worked. But that couldn't happen if it is we didn't engage others on the other side and take into consideration their positions and issues, right? And understand their positions and issues, and they needed to understand ours as well, right? So through that process, we came up with a number of options that persons could use, one of which is that under the national insurance legislation, there is a provision for persons who are on pandemic or pandemic or supposedly persons who are suspected contacts of persons who is on some type of pandemic to be on leave, and the national insurance would accept your sick leave, NIS documents, and all of that sort of stuff. So we looked at a number of ways to deal with situations like that, unique to our environment at the time. It may work for one place, but it didn't work for the others. But it certainly allowed parties from the different sides to come up with a solution in the circumstances.
Okay. Here's another question that's related to technology, all the new technologies that we are coming into the workplace and that's here already with us. What is your take on the implementation of a facial recognition system to monitor employees' attendance without agreement with the union and in the absence of a privacy policy?
If there is no agreement with the union, this is a unionized workplace, certainly that can't fly. I mean, that is unilateral action on the part of the employer. And if they don't even have a policy, and in any case, policy is subject to collective bargaining, if my understanding of collective bargaining is what it is, that it is part of the whole workplace arrangement. And policy cannot be simply unilateral either in that sense. Facial recognition and so on, what is the difference between that and some employer installing cameras in the toilet because they want to control time, how much time the employee spending in the toilet and so on. So these things are, you can't just do these things. They need to be subject to discussion with the employees and their representatives. And again, that would be a unilateral change of contract. So there are things that employers have to understand, that this notion of employers' prerogative, as was said many years ago in several cases in Trinidad and Tobago, both in the industrial court and in the civil court, that the notion of employers' prerogative with the passage of the IRA, that has been to a large extent replaced by the requirements of good industrial relations practice.
Okay. And as we talk about that, here's this other one. There seems to be a whole different employee-employer philosophy for family-owned businesses. Is this covered in any of the frameworks mentioned under the ILO or the IRA or the like?
Everybody is under the framework, regardless of the state your business is. It's your small business, multinational. Once you're operating within Trinidad and Tobago, Barbados has a different framework. Their own is a little bit more voluntary and not as defined and legal as us. Guyana, I think, has a very similar type of arrangement. Jamaica has a different arrangement. Far as I know, far as I'm aware, and I could speak to the Trinidad and Tobago context more than any of these other islands, once you operate a business within the confines of Trinidad and Tobago, you have to operate that business according to our laws. And our laws include industrial relations laws, and more importantly, industrial relations practices, which are not always defined and are found in precedents and are found in practices within industries that have become the norm and the customary norms that exist between management and labor.
Okay. All right, so yes, Janet?
I was just saying, I think with family-owned businesses, you could find a challenge where sometimes relatives see themselves as equals in the business, that one doesn't see one as a manager and the other as an employee. So unless you have some clear demarcations and some sort of formalizations, you could find challenges when both persons say that, well, you know, we were partners, we were equal in this business, I wasn't his boss, so that you could find significant challenges. And I guess that is part of the conversation in terms of this whole modernization discourse at this point in time, because family businesses do sometimes tend to fall on the periphery, depending on how they are set up, how the arrangements take place, how they interact, that and you don't see that one person was the manager and the other was the employee. So I do understand the question.
Yeah. And I think family businesses too sometimes tend to have very paternalistic arrangements, very informal.
Yes. Very informal, yes.
Very informal arrangements between the owner and the employees. It tends to be, the lines of authority and so on tend to get very blurred.
Yes.
Okay. Okay, so we're reaching.
Very paternalistic too, you know.
Well, I guess all family, family related. We're coming to the end. We are at the end of our allotted time. So I just want to get one quick word from each of you to bring us to the end of our discussions based on our topic today, modernizing approaches to labor relations in Trinidad, in the Caribbean, sorry. One word for you that speaks to, how you feel about where we are. So we'll start with you, Janet.
I feel that we need to push forward. We are not where we should be. And so my word is social partnerships and training, more in-depth training for HR managers, bringing HR managers more into the fold. They are too much at the periphery. Social partnerships.
Okay, great. Thanks. Kashta?
The one thing that I would want to leave with is it's a borrow from my grandmother, Sylvia Murray, for those in the audience who know me. And she always said, if something is important to you, do it well, because you may not have another opportunity to do it again. And if it is that we are to have the issues of modernizing our labor relations, take the time and do it well in your organization. Start there. Start in your department, start in your little areas, in your little spheres of influence, and build out from that as you go along. And slowly and surely, we will get transformation on a bigger level. Just don't sit down and wait for somebody else to do it for you.
Okay, thank you. And Clyde?
And as I said in our Facebook post some months back, COVID has brought us face-to-face with ourselves and our realities. And what we are discussing here about modernizing industrial relations practice in the region, and particularly in this country, has been a subject of discussion for at least 5 decades. And every time we make 3 steps forward, we make 2 backward, and we need to stop making the backward step. We need to be really serious and focused and deal with the issues, whether in the singular workplace or otherwise, but it's a social issue, and we need to deal with it as a society.
Okay, so I want to thank all our panelists for their thoughts with us over the last hour and a half, and to invite you to join us again next month when we would have another roundtable discussion, because this is an ongoing series sponsored by the 𝗟𝗯😅 Global School of Business. Just some quick advertisements. You can visit the school's website for upcoming programs. There is the Women in Leadership Conference, which is next month. The guest speaker is the Honorable Prime Minister of Barbados. So I invite all of you to have a look and put that in your calendar to attend. Also, applications are open for the September academic year in the 5 programs that the school offers at the master's level. You can visit the school's website to get more information with respect to applying for those programs. I want to wish you all the best. Be safe, follow your protocols, and I will see you somewhere, sometime, somehow again. Bye. Take care.
Bye. Take care, people.
Bye-bye.